Lack of communication between automotive repair shops and customers has been causing problems for years. In 1971, the California legislature passed a bill designed to improve repair shop customer communication.
The Automotive Repair Act helped to standardize the industry by giving the customer a right to know how much his repair was going to cost before the work was done. It is rare that an industry would ask for government regulation, but in this case, we wanted to standardize as other professions have been standardized. And by being regulated, the honest guys get a good name, and the bad guys get closed down or disciplined.
Why should you comply with the California Automotive Repair Act and the Bureau of Automotive Repairs regulations? Because by doing so, you may improve your business practices and your relationship with your customers. And it's against the law if you don't follow them. Even so, there are violations of the Repair Act and the Bureau regulations that occur over and over again.
But I didn't tell him to go ahead with the brake job.
He drove it over 300 miles while it was in the shop.
And when I picked it up, it was $400.
No, he didn't give me a written estimate.
Customer complaints due to violations of the Automotive Repair Act occur much too often. This program will show you how to comply with the Act and the regulations so that you can avoid the most common violations. You'll also learn about the enforcement process when violations occur. Violations of the Repair Act and Bureau regulations involve three major areas: written estimates, additional authorization, and final invoice. The most frequently violated section of the Repair Act is the requirement that a written estimate be given to the customer before any work is performed on a vehicle. All repair jobs taken into your shop must be written up on a work order. The work order must include the odometer reading, the estimated price of repairs, and your customer's authorization. After your customer signs the work order, give her a copy of the estimate and keep a copy for your records.
And once we get under the hood, if there are any other problems, we'll be sure to give you a call.
Thank you.
A significant number of violations are concerned with additional authorization. Anytime that a car needs additional work that's not already listed on the estimate, you must contact the customer for additional authorization. When you receive permission to go ahead with the work, write the name of the person who authorized the repairs, the date, time, and the phone number you called on the work order and the invoice. Also, describe the approved additional work and approved additional cost. Remember, according to the law, if you don't get the additional authorization from your customer, he doesn't have to pay you for the additional work. Other violations often involve the final invoice.
Okay, this one's all finished.
All right, thank you, Kenneth.
After the repairs are finished, complete the final invoice. It must include your business name, address, and BAR registration number. Itemize the parts you used. Include a description of whether they were new, used, or rebuilt. You're also required to have a description of your labor, subtotals, sales tax, and the notations of additional authorizations. Be sure to give a copy of the final invoice to your customer.
And the keys.
Even though you perform your work well and you do your paperwork properly, customers may still have questions or complaints about some phase of your operation. They're encouraged to contact the owner or the shop manager first. Then, if there's still a problem, they're advised to call the Bureau's toll-free hotline.
Good afternoon, Bureau of Automotive Repair. May I help you? I'm having a problem with my garage.
Not all the calls that the Bureau receives result in an official complaint. Sometimes all that's necessary is a brief explanation. A lot of times they're not familiar with the policies of the repair shop, and they're just trying to find out if, in fact, they have actually had a problem or if that's just the policy of the industry. If a consumer would like to file a complaint with us, we ask that they file a formal complaint in writing so that we can have a copy of all the paperwork. That way we can identify the information from the shop given to the consumer is in fact correct.
When a complaint is initially received, I review the complaint to determine what the consumer is asking for, what the nature of the complaint is. Generally speaking, if everything is not totally clear, the consumer is contacted for clarification. After I have spoken to the consumer and have pretty well established what it is they want or what their problem really is, I then contact the garage. After discussing what the complainant is stating in their complaint form, I'll also discuss the paperwork, particularly if there are any violations of the law, and will oftentimes point out the deficiencies. And if it is deemed necessary, we'll send rules and regulations so the repair facility owner can train his personnel in the mandatory requirements of the law.
Depending on the circumstances, BAR may issue a notice of violation to the repair facility.
The notice of violation is basically a warning notice, and it's not something that a person should panic over. It's simply a notification to the shop owner that there has been a violation of the law committed. It puts the shop on notice, and it gives us the opportunity to formally make them aware of the problem, hopefully that they would correct that. If it became a pattern, one option that we would have would be to send out a chief's letter. The chief's letter is a formal notification from the chief of the Bureau to the owner of that shop that we have noticed a problem within their file and there seems to be repeated violations which should be corrected. Gives the shop owner the opportunity to take care of his problem at that point. If after receiving a chief's letter, or if the file warrants it, the Bureau will hold an office conference. An office conference is a formal conference involving the Bureau of Auto Repair and representatives from the shop to discuss violations or noted patterns of abuse that we would find within their file. It puts them on notice, and we also at that time offer possible areas of correction, be it training or just suggestions regarding how they can take care of their errors. When compliance cannot be achieved, the Bureau has various options, one of which would be to proceed with an administrative action against the license. At that time, we would be seeking either revocation or possibly suspension of the person's license.
The Office of Administrative Hearings is an independent state agency staffed by administrative law judges who conduct licensed disciplinary hearings. We are entirely independent of the Bureau of Automotive Repair. The rights of an individual who is the subject of a licensed disciplinary hearings are set forth in the Administrative Procedure Act, which is the law which governs the hearings we conduct. A copy of that act can be obtained from the Office of Administrative Hearings or the Bureau of Automotive Repair. A licensed discipline hearing is most like a non-jury civil trial. The Bureau of Automotive Repair is represented by a Deputy Attorney General. The licensee may represent himself in the hearing or may hire an attorney for that purpose. Both sides have the opportunity to present witnesses, to cross-examine the witnesses called by the other side, and to present documents and other forms of evidence. The administrative law judge carefully considers that evidence and writes a proposed decision which calls for forms of discipline ranging from outright revocation of the license to other forms of discipline, including reimbursement of any injured party. The administrative law judge may also dismiss the accusation if the Bureau hasn't met its burden of proof.
If Bureau personnel suspect that the crime of fraud may be involved, they'll continue the investigation. If warranted, they'll present the collected evidence to law enforcement authorities.
Fraud in the auto repair industry occurs when people at an auto repair dealership mislead or confuse the customer knowingly to cause them to buy parts they don't need or have repairs done that are not needed. This defrauds the customer of his money, and his car is sometimes defectively repaired. An example of something like this would be a motorist going into an auto repair shop to get a new water pump, and the auto repair shop would take his old water pump, paint it, and put it back on the car and charge him for a new water pump. This would be fraud. Another example would be you take your car in for a check on your transmission. The auto repair dealer tells you the transmission is just totally destroyed and you have to have another one, when in fact it is in good shape, and they put in a replacement transmission that is not needed. Occasionally, we will receive information that indicates a pattern of abuse at an auto repair dealer. Sometimes customers will come in and complain that they went to, say, a brake shop for a $39.95 brake job and were charged significantly more than that. After we see a number of people, say 10 or 15, with excess charges, we will then check their vehicles and run an undercover car on the shop. And this may indicate that work is being done that's not needed to pad the bill, or that in fact no one is given the $39.95 job, and that would be a misleading or fraudulent statement.
The Office of the Attorney General represents, as the lawyer of the Bureau of Automotive Repair, the Bureau when it takes an action against one of its registrants or its licensees. That is, we file the accusatory pleadings, we investigate the case in tandem quite frequently with the Office of the District Attorney in the county in which the action took place. We then look to subpoena witnesses, provide testimony, and we supervise undercover operations as well. The types of things we look for, number one, are a pattern in practice, and by that is the conduct of the registrant or licensee. If there's a pattern being developed or apparent from that conduct, we look to that. We look to the volume of complaints against a particular repair facility. Strong consumer complaints are very helpful, and ultimately undercover operations we also use. If there is a conviction, it can range from grand theft, which is a felony or a misdemeanor and carries state prison time with it. If there's a conviction for false advertising or making false promises likely to induce a customer to authorize repairs, then you're looking at stiff civil penalties, and in addition to that, you're looking at possible restitution orders. Ultimately, the negative publicity that generates can be a death blow to any repair facility.
Following the regulations and the Automotive Repair Act should help you avoid complaints, notices of violation, office conferences, undercover investigations, and appearances in court. The regulations are basically quite simple. Keep the customer informed. Do only the work that has been authorized, and keep a written record of all work that's performed. By complying with the regulations, you'll be improving your business practices and your communication with your customers.
Our people too often fix the car, want their money, and don't talk to the customer the way they should. That communication link is a requirement of the Auto Repair Act, and our members are using that now to improve their relationship, and it brings about repeat business.
I have been a shop owner since 1975, and I have found that working with the Bureau of Automotive Repair, working within their guidelines and regulations, I have found that we have a much better customer relationship. We don't have any 5 o'clock surprises or customer confrontations, which in turn is very good for our business.
Smog. We know it's unhealthy for us, yet there are a number of areas in California that do not even meet federal air quality standards. The Smog Check program has been established in these areas to reduce emissions from automobiles, one of the major causes of air pollution. Cars registered in the Smog Check areas must have their emission systems inspected and, if necessary, repaired every 2 years.
The two leading complaints in the Smog Check program are no emission control system inspection and a failure to issue a certificate signed by a licensed inspector.
Smog checks can only be conducted at stations which are licensed by the Bureau. Mechanics have to be trained and certified by BAR. All the procedures outlined in Part 1 of this program also apply to Smog Check customers. Providing a written estimate, getting additional authorization for additional work, and giving the customer a final invoice. When mechanics fail to follow state law or regulations concerning the Smog Check program, they are issued citations.
When the Bureau has probable cause to believe that a shop, a mechanic, or an inspector has violated the law, we will issue a citation. A citation technically is an assessment of a fine. The first citation is issued at an office conference. A program representative from the Bureau has the shop owner, inspector, or mechanic brought down to the Bureau office and explains to that person the violation, the facts behind it, and the law. The person is informed that a follow-up undercover run will check for compliance. If the following runs indicate continuing violations, subsequent citations are issued. The first level citation is $250. A second violation is $750. A third violation is $1,500, the maximum for one violation. A fourth violation results in the Bureau processing the case for license revocation of the responsible party. If the person receives a citation, they have a choice. They may pay it within 30 days, or they may appeal the citation and have a hearing separate from the Bureau. If the person who receives a citation fails to pay the citation within 30 days of it being issued, the person will lose the right to renew their license and will not be able to purchase certificates of compliance for the smog check program.
Of course, you can avoid receiving a citation and going through the citation process if you follow the regulations in the Automotive Repair Act. It's good for business, too.